This show is pre-recorded and furnished by Karl Gerber and Employment Lawyers Group.
Lawyer and I know it.
Talk Radio 790 KABC. This is the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, and I'm a real workplace lawyer.
I'm not a hippie.
I'm homesick for my city. I miss all the angels. Black, white, Persian, Latino, Asian, hipster, and families too. The shy lottie goers. The jerks in the BMWs. Gold chains. Armenians in cafes. The coffee. Not the coffee from home, but the boiling pots at counters run by neighborhood merchants. The smell of plywood in Home Depot. Seeing other people on the streets. My Los Angeles. The city of angels. Someday, I hope to be back in my city with the people of Los Angeles, the employees of Los Angeles. These are dark days, people. I'm a labor lawyer, and I come into work every day. I'm the only one that can come into the office because it's my business. I answer the calls at 877-525-0700. That's 877-525-0700 if you want a real employment lawyer. 525-0700 of the 877 variety. Well, I answer these calls, and they're just people that have a question. They wonder, can I be fired for not putting on a face mask? I tell them, haven't you been listening to the news? Everyone has to wear face masks now in Los Angeles. Why don't you want to put one on? Some of them tell me, well, I've got asthma. I don't want to put one on. I've got asthma. You have to wear a face mask. And if you can't, it might be a disability that your employer can't accommodate. The calls I get are sad. All kinds of layoffs, people being fired. There's no remedy. The place is out of business. It's uncollectible. A paycheck's late. Does the company have the money? Will that paycheck ever be paid? It's just awful these days. I told you on the last episode of this show, well, it is winding down on KABC. It's this episode and one more, but the show's not leaving Los Angeles radio. There are two offers from two separate FM stations and one AM station. I think there might be more. We might just go online for a little while until this coronavirus thing is over with. It's very hard to put together my show with quality voice actors and actresses. We have to be in the same room at the same time. And I don't want to do a show where I'm calling in because the audio quality is terrible. Last week, the audio quality wasn't great on the show we did. We were on Zoom and recording with Dumas and Myron Alfumbra, pronounced Manning but spelled M&M, and the Soldier, and some of our voices sounded better than others, but it wasn't great sound quality. And so, until this coronavirus thing is over with, I can't bring you the level of comedy that you deserve. Tonight, we're going to talk about employment law. I told you when this show started in 2018 that if you listen to some of the episodes, you might get a junior high school education on employment law. I told you that if you listen to more episodes, it might be a high school level, a college level, maybe someday a PhD. Well, we've talked about a lot of things on this show, and a lot of it's been comedy. This is episode 106. You should go to the Karl Gerber with the K channel on YouTube, and you should subscribe because there might be a time we're only on the internet, and I don't want to say too much about the other stations we'll be on. That wouldn't be fair to KABC, which has been a great station, and they've been actually very liberal and very accommodating in letting me do the craziest, most out there comedy in Los Angeles. They gave me complete artistic freedom in the show. They didn't make me do anything. I came up with the scripts, I provided the actresses, the actors, and KABC didn't tell me it was too much or they wanted a certain way. And one of my fears in going to another station is it might not be that way. But at any rate, I do want you to listen on the Karl Gerber with the K channel to the older episodes. But tonight, I want to tell you about how you get a case in California, because that's where I think most people just don't get it. And you should know how you get a case against an employer, because pretty much just about everything is not a case. I want to start off by talking about wrongful termination, because most of the calls we get at 877-525-0700, which I have to answer myself these days, most of those calls are about people that think they've got wrongful termination, and most of them don't. Candidly, we can go through 100 calls before it's actually a case. Okay, so there's something called wrongful termination. We all know that. We've all heard that. And I'm going to tell you what it is, but I want to tell you about some of the special circumstances first, where if you get fired from your job because of it, there's a way to sue. One of those things is if you're on a jury trial. You can't fire somebody because they have jury duty. Well, these days, there isn't any jury duty going on, but it's going to come back. You also can't be fired under certain circumstances if you're the victim of domestic violence. Certain circumstances, the kind of thing you'd really need to talk to me about at 877-525-0700. I'm going to take calls on the breaks, on the commercial breaks, and you can call me right after the show. All right. So if you have to be a witness in a case and you've been subpoenaed and you get fired, that's also protected. One of these episodes we had, the first episode with the soldier, way back in probably 2018. Well, he was thinking he might be getting fired for military duty. If you're fired for military duty, that can be wrongful termination. If you have to go out for alcohol or drug rehab, it's a little bit complicated. There might be a case using federal law. There also might be a way to go with the labor board, essentially, but you don't have a normal wrongful termination case. I don't like taking those cases because it's very hard to deal with people that are addicts, and they oftentimes go in and out, and on a contingency, that's just not the kind of thing a lot of times we can do. You also can't be fired because you wanted to vote, or if you're a parent and you had a school visit. We had an episode way back with Cindy D, and that's when we found out that she had an 8-year-old daughter at the time who was 7, Virgin, who was a genius, and Cindy D had to miss work to go and get that daughter enrolled in the school for the geniuses, and Delicious Divine fired her when she was working at Underground Operators. Now, you probably heard on later episodes she got hired back, but that would have been a wrongful termination case. Volunteer firefighters also can't be fired. You can't be fired because you have sick leave or illnesses. There are a couple other little special ways you can get wrongful termination. But some of the bigger ways are if you are not being paid your wages, you complain you're not being paid your wages, and you get fired for complaining. So that would also create a case. If you have been defrauded into accepting employment and you say, hey, I've been defrauded, you're not giving me the pay you promised, and maybe this isn't the job you promised, and all of a sudden you're telling me I can't live where you said I could live if I had this job, that might create wrongful termination. Wrongful termination is based upon statutory rights. It's based on a right in a statute that says you can sue for it, or it's based upon there just being a statute that says what you're complaining about, what you're refusing to do is a legal right of yours. And when we come back, we're going to talk about that because that's very important. Please call me at 877-525-0700 if you think you were wrongfully terminated or forced to quit for complaining about something illegal at work. 877-525-0700 for the Employment Lawyers Group. We have a lot of offices in Southern California. We're signing people up by the internet right now. So if you have an unpaid wage case, maybe You weren't sure you wanted to sue your employer until they laid you off, and now you think you might want to sue because there's some wages you never got paid, meal breaks, commissions, whatever it is. Call me at 877-525-0700. This is the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC.
Since 1993, the Employment Lawyers Group has been a results-oriented law firm whose goal is to get the client what they deserve. They've represented thousands of California employees who've lost their jobs, been sexually harassed, subjected to employment discrimination, or were owed wages on an individualized or group basis, such as a class action. They have a high rate of success. There are few situations involving employment law that they have not confronted. At the forefront of employee rights, they're often the first employee law firm to confront a new legal issue. For an experienced employment lawyer, call 877-525-0700. That's 877-525-0700. They have call takers standing by. Online, read more about the firm at employeelawca.com. They have offices throughout Southern California. Make your work problem theirs to solve.
The Smell Good Plumbers at Mike Diamond will unclog your drain for $99. Having your stoppage unstopped by these aroma-friendly technicians can save you money, prevent flooding inside your home, and remove all unnecessary worry from your life. Your drain will drain more efficiently, your pipes will flow smoother, and your faith in mankind will be restored. This $99 unstopped rate applies to kitchen sinks, mainline sewer stoppages, and all 5 coronary arteries. Schedule an appointment today and your Mike Diamond Plumber will show up on time, act professional, and smell better than a new car wrapped in bacon. You will be able to get back to life sooner, focus on things that really matter, and avoid the unsanitary atrocities of Bubba the Butt Crack Plumber.
No Bubba's here, ma'am.
Got a clogged drain? Reference the $99 stoppage page at thesmellgoodplumber.com. Then call 800-446-MIKE. Contractor license number 399170.
This is Mike Diamond, and I guarantee my plumber will show up on time and smell good, or your house call is free.
Have you wanted to speak a new language, but you thought it'd be too hard or take too much time? Then go to Babbel.com, download the app, and try it for free. In just 15 minutes a day, you'll be on your way to speaking a new language in just a few weeks. And right now, you can try Babbel for free. Babbel starts out teaching you words and phrases by matching them with pictures. You won't believe how easy the interactive program is. Soon the sentences get a little bigger, and before you know it, you're having simulated conversations voiced by native speakers. And because Babbel is crafted by language experts and uses the spaced repetition method, in just 10 to 15 minutes a day, you'll be speaking the language of your choice with real confidence. With Babbel, you can speak a language. Just go to Babbel.com and start your first lesson in the language of your choice for free. Download the Babbel app or go to Babbel.com and try it for free. That's Babbel.com.
Get an entertaining take on the morning news.
Can you make that happen?
Yes, actually, yeah.
The Armstrong and Getty Show, morning 6 to 10 on AM 790 KABC.
Yeah, I'm a lawyer and I know it because this is Karl Gerber on the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC. Tonight, we're just going to be talking about how you actually can sue your employer in all the different ways. And before we broke, we talked about how wrongful termination is either a right to sue your employer through a statute or there's a statute being violated. Now, what I'm talking about doesn't apply if you're a government employee, and it doesn't apply if you're in a union. Your rights are different. If you have an actual written employment contract, you may have some rights that prevent you from being fired too. But for most people who are just private employees in California, you have to be fired because you complained that your employer was doing something illegal, forcing you to do it, or it was just illegal. How do you know if it's illegal? Well, there are laws called statutes. The legislature makes statutes. It's not something a court makes. And those laws can be federal laws or they can be California state laws, and possibly they can be building codes or county or even city-made laws. But what happens is you complain to your employer that they're doing something that you think is illegal or you think it's suspicious may also count. You have to have a reasonable suspicion that it's unlawful conduct. And you complain and then you get fired. That's wrongful termination. If you don't complain, not a case. If your employer doesn't care that you complain because everyone else is complaining and they're fired because you get into a fist fight, that's not wrongful termination. So it's very limited ability to sue for this. Now, it could be something like a car dealership, and you're telling your employer, hey, I'm not going to do this. I'm not going to pretend that this is a new car when it's not a new car and it's been used for the customers when they come in to get service on their cars for a year and it has 10,000 miles. I'm not selling it as a new car. Or you say, we're engaging in fraud at a doctor's office. I don't want to do this. We're billing the government, Medicare, Medi-Cal, for treatments that didn't exist, or we're saying that these treatments were medically necessary when they weren't, or maybe the patient wasn't even at our facility and you're trying to falsely, fraudulently get money from the government. I don't want to do it. I don't care if the rest of my workers do it. I'm not doing it. Well, you know what, Joe? If you're not doing it, you're fired. That is wrongful termination. All right, so if you just don't think the reason for being fired is a good one, it doesn't sound right, that doesn't create wrongful termination. And there's a case that I remember reading when I first became a lawyer in 1993 called Hunter versus Upright. And it says that the employer can even give you a phony reason for firing you, an untrue reason, a false reason, as long as the real reason for firing you doesn't violate public policy, which gets back to it violates a statute, an ordinance, the California Constitution, maybe the U.S. Constitution. So that's how you get wrongful termination. And furthermore, you actually have to prove that connection, that the reason why you were fired was your complaint about something illegal. If you quit, you can quit and sue under some circumstances in California if the working conditions are intolerable. And it has to be intolerable to a reasonable person like you under your circumstances. Now, if you just one day walk out and quit and say, you know what, I don't want to work here because you're defrauding customers, that may not do it, because the law may require you to work with your employer a little bit and say, look, I think what you're doing is wrong. This is why. I'm giving you X amount of time to fix it. If it doesn't get fixed, I'm out of here. But to simply walk out doesn't work. But if the employer knew that you were subjected to sexual harassment for years, or that you were tired of falsely pretending that a doctor authorized a medical treatment that they didn't because maybe just a nurse saw the doctor and they knew that, and you say, I've had enough of this, I told you I can't take it anymore, maybe you can quit and sue. But these are questions that you really need to talk to a lawyer who's experienced. I'd call me at 877-525-0700 if you want to see if your situation is good enough. The other thing is, it's got to be good enough to take on a contingency, because I'm going to spend 400 hours on your case, and I can't do that if it has a marginal chance of success. 400 hours is 20% of a lawyer's time for the whole year. So that's a lot of time. So call me at 877-525-0700 if you want to sue your employer because you were being made to do something illegal, or you quit because you were being exposed to something illegal and your employer knew. That's 877-525-0700. That's not going to get you on the air. It's going to have you talk to a very experienced employment lawyer. And you also can call that number between 9 a.m. and 6:30 p.m. And do leave a message if we can't get all the calls. It's hard when you don't have everyone working in the same office right now. Wrongful termination also exists if you're being fired because of a protected medical condition, which would be a disability. So it's a little bit redundant to sue for wrongful termination, also disability discrimination, a violation of the Fair Employment and Housing Act. That's FEHA, but we do it, and God forbid if a jury decides there's wrongful termination but no disability discrimination, that could be a screwed up verdict, because you can't get wrongful termination without there being that statutory violation like the disability. So the protected characteristics under the Fair Employment and Housing Act are age, cancer, genetic conditions, disabilities, of course, pregnancy, national origin, ancestry, race, sex, your sexual identification too. Your sexual orientation is protected, religion is protected. I think I already said race. So if you're fired for one of those things and you can prove that's why they fired you, not just, yes, I was pregnant and yes, I was fired, but I don't know if my pregnancy had anything to do with it, then you can be suing for wrongful termination or for a statutory right for losing your job under the Fair Employment and Housing Act. When my practice started in 1993, really all I dealt with were job terminations, and occasionally those would be breaches of contract. Two, we weren't doing a lot of wage and hour cases back then. The laws weren't on the books. They just weren't as popular. The class actions hadn't exploded. So certainly wrongful termination is something I have a lot of experience with. And so are the disability cases, the age discrimination, pregnancy discrimination, race discrimination, maybe also national origin, ethnicity discrimination, ancestry discrimination, all those things. I have done many, many cases like that. If you want to call me and you want to sue, 877-525-0700. These days, with having to work at home, we can't just give legal advice on the phone if you don't want to sue. We had problems doing that beforehand because I think it's malpractice to give people advice on the phone. I think you need to see documents, you need to sit with them for 2 hours, and it's just not feasible. And we don't charge people when they call up on the phone. I've often thought about, what if we took credit cards? I don't know. We don't do it. I don't know how much we'd make. And I think a lot of it would be, no, you don't have a case. No, you don't have a case, because most things are not a case. One of the reasons why I did this show was to hopefully educate people how you do get a case. I know we got a little carried away with character comedy, but some of those examples were so out there that I thought people would remember them and would remember the law. The first segment of the show, the first 2 segments, we've really talked a lot about losing your job and suing. We're going to talk about some of the other things you can sue for besides a job loss, but I think that job loss really is what motivates most people to call. Job loss is what bothers people a lot, and right now it's just a problem. So you might have a contract. Some people actually do have written contracts with their employers. That's something that I'd have to read. I'd like you to call me at 877-525-0700. We'd talk about how you get the contract to me, because oftentimes the contract doesn't do what the employee thinks it does. There may be a clause in there about if you're fired, well, you only have to get paid 30 days pay or just some minimal amount of thing, which doesn't get you your full term of the contract. And sometimes things aren't contracts either because they're too indefinite. They don't say how long this is supposed to be, or nobody signed it. I've had cases where the employee never signed it, and I've had cases where the employer never signed it. If it hasn't been signed, probably not going to be a valid contract. The law is that it has to be signed by the party you want to assert against. So an employer might be able to enforce that against an employee who signed if the employer didn't sign. But the question is, why didn't the employer sign? That doesn't seem right. Okay, so you need to call me between 9 o'clock and 6:30, although I'm taking some calls on the commercials here. 877 525-0700. Be patient because I'm taking the laboring oar and answering all the calls for the Employment Lawyers Group. And in a good week, that's more than 200 new client calls. 877-525-0700 to find out if you can get a lawyer on a contingency to represent you on a case against your employer. 877-525-0700. My real specialty these days are unpaid wages, class action, sexual harassment, if it isn't just wrongful termination. This is the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC.
AM790
KABC.
Talk Radio 790 KABC News Update. I'm Steve Cumming. The first round of stimulus checks are being deposited in taxpayers' bank accounts. The IRS made the announcement on social media today, saying they know how many people are anxious to get their payments. The average American who made less than $75,000 can expect to receive $1,200. A Florida doctor is temporarily losing custody of her child because of the pandemic. Emergency room doctor Teresa Green tested negative for the coronavirus, but her ex-husband is worried that her job could endanger their daughter. The parents share custody of the 4-year-old. In a ruling, Miami-Dade County Circuit Judge Bernard Shapiro said his ruling was intended to protect the best interests of the child. KABC SoCal weather, partly cloudy this evening, then cloudy overnight with patchy fog and drizzle after midnight. Lows tonight in the lower to mid-50s. Easter Sunday, mostly cloudy with patchy drizzle in the morning and highs in the lower to mid-60s. I'm Steve Cumming. We're on the News Watch 24/7 for you on AM 790 KABC.
Please listen. This is important. Anyone can be affected by the prescription opioid crisis. If you think you've been hurt by Purdue or its prescription opioids like OxyContin, you may be entitled to compensation as part of Purdue's bankruptcy, but you have to file a claim. Claims may include overdose, death, substance use disorder, lost wages, and neonatal abstinence syndrome. A confidential claim can be filed by individuals, a legal guardian, by survivors or relatives of people who have died or are disabled. The deadline to file a claim is June 30th, 2020, or you will lose your right to file a claim. For more information, visit PurduePharmaClaims.com, or you can call toll-free 1-844-217-0912. That's 1-844-217-0912. Paid for by Prime Clerk, LLC.
From Woodland Hills to Chino Hills. Get it. Get it. Right. AM790 KABC.
All right, this is Karl Gerber on the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC. I'm a real workplace lawyer in addition to being a writer, comedian, and Los Angeles historian. And I have actually been representing employees since 1993. I'm licensed in California, Texas, Massachusetts, and Washington, D.C. We're tonight talking about how you get a case because I promised people when the show started 2 years ago that if they listened to all the episodes, they'd be getting an education. And the more shows they listen to, the higher their education would be on employment law. So we've talked about wrongful termination, which is why a lot of people call me at the office at 877-525-0700. But I also want to make clear that there are cases where people have not lost their jobs that we get involved in, and one of them is sexual harassment. When this show started, I was approached by KABC to do a show on sexual harassment. There was a lot of this Me Too stuff going on, seemed big. I'd written some articles that were featured in major New York magazines about the whole Harvey Weinstein thing. That might be how they found me. I don't know. And I told them I thought the show should be about all employment law because sexual harassment's a little bit narrow. It might get a little bit boring. The cases are interesting, but it's just one of the things that is done by an employment lawyer. Sexual harassment involves sex, does it? Well, not really. It doesn't really even have to anymore. In the olden days it did. It needs to be offensive conduct. That's key. If it's non-offensive, it's not sexual harassment. And there are some of these cases where, it's just not enough. He was staring at me, and did he say anything? No, I just knew what he meant, or there's one comment or something like that, and it's not enough. So that's where you really need somebody who have done hundreds of sexual harassment cases, tried some like me, to tell you if it's going to work in court or in arbitration as a sexual harassment case. Sexual harassment cases are potentials to be thrown out by a judge before they even get to a jury. That happens because the conduct may be too minimal. And it used to be if there was one comment, that would get the case thrown out. And there's been some amendments, but I don't think I'd take a case if there was one comment or one touching. I just don't think I'd do it. I think that's a lot of work. It's going to subject the client to depositions and a lot for one comment or maybe one touch somewhere, even if it's a touch where it shouldn't be. It might just be too much to involve the legal system in that. You have to pick your battles, and that's something I think a lot of clients don't understand. But sexual harassment is physical touching, obviously, and it doesn't have to just be the breasts or the buttocks. It can be touching people on their face, it can be touching their hands, it can be wanting to make contact, putting yourself in a position where it's likely that you will touch this person. It's a close quarter restaurant area, and so if you stand there, that person is going to rub against the side of you. That might also be an assault. It might also be battery. It might be a sexual battery if the sexual organ is touched, like, the buttocks, genitals, things like that, breasts. So if it's a physical act and it's not intended, that becomes a little bit strange too. Someone is passing by and it really is close quarters and they make contact and it's one time or it's even two times, maybe not something to sue. You have to indicate the conduct is unwelcome, and you could do that by raising your eyebrows. You certainly could do it with words or a text message, but not a text message, "Don't you ever touch my butt again." And then the next text message is, what's your grandmother's recipe for potato salad? What did you say it was? And oh my God, I can't believe your cookies are turning out so well. I've seen that in cases, and that is not really the way that the public expects that you'd be reacting to someone making your life miserable. A lot of people say, I just wanted to be cool with this person because I had to work with them or they're my supervisor. But the question comes, well, why didn't you say, I don't want to talk to you? Or if you're texting them about cookies, why aren't you texting them about, I don't want to be talked to that way. I don't want to be touched that way. So sexual harassment, unwelcome. We've got that much. We also know that it can be physical or verbal. A lot of cases now involve text messages, and those are good cases because it proves that it happened. The text message doesn't go away. But the ones where someone's claiming there are all these text messages and they don't have any of them are a little bit suspicious. I'd like to talk to you about whether your case is going to work as a sexual harassment case. Call me at 877-525-0700 during normal business hours. That's my office. 877-525-0700 to have a heart-to-heart discussion about whether you really should bring the lawsuit, whether it's the right thing to do, whether I feel it's strong enough that you can win, whether it's a good enough case that I'd take it on a contingency, or maybe I'd refer it to someone else because I don't think it's a quite good enough case for me, but it might be for someone else. Call me at 877-525-0700 if you want to find out if the situation is going to work as a sexual harassment case. I've done probably 500 of them, and I understand how it works, and I'll try to be as nice as possible in talking to you about it. It's a delicate subject matter, and if you give me professional courtesy, I'll give you professional courtesy. I do tell all people calling who are, not calling, but people on the internet or people here, that you really need to let me ask the questions. I know what questions that have to be asked, and if you just come on the phone with a long story, it gets very hard to get the right information, and you may be providing a lot of information that isn't really going to get to the point. And I want to make these representations for employees as efficient as possible. If I've been doing this for almost 27 years, the number of cases I've done, and I know I've taken more new client calls in employment law than anyone else alive in this country. I know that, and that's one thing I will guarantee. If I can't use my experience to get you through this faster, then I'm not doing my job. You've got to let me get you through this as painlessly as possible, as quickly as possible, and as good as possible, so you're focused on doing what you need to do on the case, not what you don't need to do. So if you do need to call me about an employment case, 877-525-0700. I'm Karl Gerber. It's the Employment Lawyers Group. You can go to the Karl Gerber with a K channel on YouTube to hear the comedy that's normally on this show. There is some serious legal content on there too. And there's plenty of serious legal content on the firm's websites for the Employment Lawyers Group. It's not hard to find them. We have a lot of websites. The only bad reviews we have are from people who were never our clients and didn't like the fact we rejected them on the phone. We reject a lot of people. We don't take cases that can't be won. It's not right to take cases that can't be won. It's doing a disservice to the client. There might be some low-value settlement in there, but that's not what you're supposed to do as a lawyer. You're supposed to bring cases that you believe have merit. And if they don't have merit and you can't win them, you don't bring them. Short and simple. And you don't subject clients to the unreasonable expectation that all these things are going to happen to them in their case when they're probably going to lose it before it even gets to a jury. So besides sexual harassment, there also are work injuries that can be sued for if the person is still working. I got a lot of calls about workplace harassment, and it's not sexual harassment. It's not based on a protected characteristic like race or a disability or pregnancy. It's just what I guess you could say is generalized harassment at work. Now, technically, it's got to be based upon a sudden act like a store robbery or something that suddenly and unexpectedly happens. Maybe an outbreak is going on at work. That is how you're supposed to get work stress. But I know that some of these cases that I'm told are work harassment, those actually work, and we can bring them as workers' comp cases. And there's nothing bad about workers' comp. It's a lower legal fee than the civil court system. I've seen some pretty good settlements on those stress cases. I think you should bring them. Now, what you do have to do is you're going to have to get medical attention. I don't think the workers' comp system is really the system for compensating people who have had work stress if they haven't gone to a therapist or won't go to a doctor for it. So I do want to throw that out there. You really need to be at the company 6 months too. Less than 6 months, there are problems bringing a case for workplace stress. So generalized workplace harassment, maybe workers' comp. You can call me at 877-525-0700. You heard Seth Krell on the show once. He's a workers' comp specialist. I work with him on the workers' comp cases. 877-525-0700 if there's a work injury, sexual harassment, wrongful termination. 877-525-0700 if it's any type of case you're ready to bring against your employer. Now is not the time just to answer general legal questions. I'm sorry. Resources are really spread right now with people working from home. That's why you're hearing me in my recording studio, not at the station, trying to give you adequate sound quality, because I don't want you to hear bad sound quality, and I don't have voice actors tonight. Go to Karl Gerber with the K channel on YouTube and subscribe. Listen to that stuff. It's the craziest comedy that has hit LA in a long time. This is episode 106. Most of the show was that way. So again, I'm Karl Gerber. You can call me at 877-525-0700 on the commercial break. I'm going to take calls, but that's my number that rings at the office. It just happens to be I'm carrying a cell right now that forwards those calls. So call me at 877-525-0700 for an employment lawyer. This is the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC.
Since 1993, the Employment Lawyers Group has been a consistent force in fighting for the rights of California employees. They've represented thousands of employees in cases in which they've lost their jobs, been sexually harassed, discriminated against at work, or owed wages individually or as a group such as a class action. The Employment Lawyers Group has maintained a high win rate and a serious record before the California courts. Please call 877-525-0700 for an experienced work lawyer. That's 877-525-0700. They have call takers standing by. Online, research the firm at worklawyerca.com. They have offices throughout Southern California. If you hire the Employment Lawyers Group, your legal problem becomes theirs to solve.
Please listen. This is important. Anyone can be affected by the prescription opioid crisis. If you think you've been hurt by Purdue or its prescription opioids like OxyContin, you may be entitled to compensation as part of Purdue's bankruptcy, but you have to file a claim. Claims may include overdose, death, substance use disorder, lost wages, and neonatal abstinence syndrome. A confidential claim can be filed by individuals, a legal guardian, by survivors or relatives of people who have died or are disabled. The deadline to file a claim is June 30th, 2020, or you will lose your right to file a claim. For more information, visit PurduePharmaClaims.com, or you can call toll-free 1-844-217-0912. That's 1-844-217-0912. Paid for by Prime Clerk, LLC.
Okay, kids, Dad's gonna teach you how to dance. First, spread your feet apart. Then, pump your knee.
Dance like a dad. It's a great way to make a moment with your kids. Visit fatherhood.gov. Brought to you by the U.S. Department of Health and Human Services and the Ad Council.
For those fortunate enough to help the person who has always been their hero, find the care guides you need to help at aarp.org/caregiving. Brought to you by AARP and the Ad Council.
Text and work. Text and pretend to work. Text and act surprised when someone calls you out for not working.
Who, me?
Text and whatever, just don't text and drive. Visit StopTextsStopWrecks.org. A message from NHTSA and the Ad Council.
If you love them enough to barely sleep, then surely you'll check NHTSA.gov/the right seat to make sure they're in the right car seat. Brought to you by the National Highway Traffic Safety Administration and the Ad Council.
AM790 KABC. Hunker down at home?
I'm going crazy!
Spend your day with AM790 KABC and Alexa. Get the latest coronavirus news on air, online, and on your smart speaker. Stay safe, stay informed. AM790 KABC.
Okay, so at the base of all this craziness you've heard on the Karl Gerber Workplace Lawyer Show here on Talk Radio 790 KABC, I really am a lawyer. I'm licensed in 4 states. I've been a lawyer since 1993. And this show, we're talking about how to actually get an employment case. We're not doing scripted comedy. That you can listen to on the Karl Gerber with a K channel on YouTube, which I strongly encourage you to subscribe, because next show is my last show on KABC. The show's going to move to another radio station in LA, and there's going to be a brief hiatus where it's going to be just on the internet because of the coronavirus. There are limits to what kind of productions I can give you because no one can be in the same room. I don't even really want to come into the studio right now. I'm recording this. You can hear me, and I've got professional equipment at my recording studio. Okay, so we talked about wrongful termination. That's a case. We know that sexual harassment's a case. There are work injuries if you're still working at the company that you can sue for. Work stress you can sue for. We have not talked about unpaid wages, and that's really a big part of my practice. Unpaid wages can exist at all levels of employment. It's not just people that are hourly. The hourly people have different rights, and they have a lot of rights. The overtime thing is an issue. So is double time. And these days, it has to be paid at the right rate. There's a case came out called DART, and I believe it's Alvarado versus DART. It's not new anymore. It's a couple years back now from the California Supreme Court. And it says that if you're getting fixed rate bonuses, your overtime rate has to be based on the fixed rate bonus. So there are a lot of cases now about did they pay me the right overtime, and they're big cases. I've got them, and I've got big money in these, like $350,000. So those may be cases you want to call me about if you got the right rate for overtime because you had a fixed rate bonus, whether it was a rent credit, whether it was a show up to work thing that happens in the oil fields. All kinds of situations. Daily bonuses are paid at different jobs. Call me at 877-525-0700. Normal business hours are right after the show. I'm going to take some calls. 877-525-0700 to find out if you can sue for unpaid wages. Overtime and double time are certainly not it. A lot of labor codes came on the books during my career, actually. Meal breaks are a big one for the people that are non-exempt. Non-exempt means that you're not supervising people 51% of the time, or maybe 50% and a feather. It doesn't have to be much more than half before you start getting exempt. And you have to make enough to be exempt if you're a manager. It's twice minimum wage, by the way. There are plenty of professions that are exempt. If you got a license, you might be exempt. Lawyers are exempt. Doctors are exempt. Social workers are exempt if they're LCSWs. If they're bachelor's degree levels, maybe not. Accountants, maybe not. CPAs are. Very technical about who's exempt, the kind of thing you got to talk to me at 877-525-0700 about. So we've got the situation where there are commissions. We got a lot of commission employees in LA. I got a call in the middle of the show last week from a salesperson, a lot of salespeople. Commission cases are big cases. I had one that was 1.15 million, and I remember that because that was like 2002, and it was just contract for software, and big commissions weren't paid. So you may be owed commissions, and they may be huge. I've had a lot of commission cases where people are owed a lot of money in commissions, and if you're fired because your employer doesn't want to pay you the commissions, that's a case too. Besides overtime, double time, meal breaks, there's also rest breaks. We all know that. That does not apply if you're exempt. Now, the rest break cases, I'm probably not going to take one if it's one person. It would have to be one person to work there a while. There'd have to be other issues because, it's 1 hour pay for every missed rest break, and that just doesn't add up to that much always. If they're meal breaks too, it's a little bit better, but those are the cases where I generally have groups. I refer the cases to people if it's just one person. They're lawyers that like to negotiate the smaller wage and hour cases and maybe even go to the labor board with it. They know the employer has to pay, and so they are willing to do it. But for me, I can't really be taking cases that are worth $3,000 to $10,000. It just doesn't really work because I've been doing this a long time. I have a lot of staff, and I'm doing these cases for that kind of a thing, at least meal and rest breaks, for groups of people, class actions, or PAGA, which are private attorney general penalties. A bad word to some employers, but it is on the books. It is the way the California wants it. We go in and we act as a private attorney general, and we are able to get fines that are based on violations of statutes for labor conditions that generally only the government can get. And that's interesting. I do a lot of that. I was one of the first people doing PAGA back in 2004, doing lectures on it. I've had arbitrations on it, trials. I really have a lot of experience with PAGA. It is a way to get money for the government too. They end up getting 75% of it. The employees only get 25%, but it can be significant money, and it can motivate a wage and hour case to settle because the PAGA penalties are so grave the employer doesn't want to deal with that. And sometimes it's fun when they don't want to settle the case to just let them try it and lose it and sit back and watch how much they have to pay in penalties. There are many unpaid wage scenarios. On call is something that I have particular experience in. People that are waiting to be called to work, and if the time that they're spending at home is primarily for the benefit of the employer, they have to be paid for that. So that might be people like nurses. I've represented and represent a lot of nurses who are on call, oil field workers. You can't make somebody sit around waiting and discipline them if they don't pick up the phone and not pay them. That's just not how it works. The test is whether the employee is out when they're supposed to be on call, just doing whatever they normally do. But if they're primarily sitting in their house, and even if they're watching TV, well, that isn't the most, involved experience. What else can you do? They are probably going to have to be paid for sitting and waiting to be called to work. Please call me if you have an on-call case. I have particular expertise. I think I'm one of the lawyers that does more of those than anyone else. 877-525-0700. It's also called controlled standby and reporting time pay. They got to pay you half of your wages if they make you report into work. Half of your wages, what you'd earn for the day, or at least 2 hours. And that only applies to people that are non-exempt. 877-525-0700 is my office. What other pay situations are there? There's some cases for unreimbursed expenses. We have a published opinion on that. And I don't know how big those cases generally are. It's usually a side issue. Now, I have some cases where there are mass numbers of people that are not being paid for their cell phones. And that's an interesting issue now because there's a lot of people using their cell phones from home. And so the question is going to be, what obligation does the employer have to pay some portion of that cell phone bill, especially during the coronavirus epidemic? But I have cases where they're out in the community with disabled adults and they have to use their cell phone to communicate with the employer all day. And these people are making basically minimum wage, maybe a quarter an hour less. So these are people that really can't afford to be having a cell phone that the employer is getting such a benefit from and not getting anything from it. The same with an oil field case I have right now, where in order to get your work, you got to be on that cell phone, but the employer is only issuing the cell phones to some people. So cell phone reimbursement cases have become a thing now, and a lot of times they are class actions, group actions, not the kind of thing you'd be able to bring for one person. It's going to have to be a side issue. Stock options. I've had cases where someone isn't paid a stock option. They can be big. Cases where someone isn't paid a bonus also can be big cases. On the wage and hour variety, unpaid wages. There's a lot of scenarios, also minimum wage. I don't know how many of the listeners here are not getting minimum wage, but there are different rates for different cities and counties and places you work. Hotels may have a different minimum wage. It's a little bit confusing. And piece rates. If you earn piece rates, your overtime has to be based on your piece rate too. And you have to get your final pay. If you never get it, there can be fines. But that is something that the judge would have discretion in. So some of these cases, especially now, if no one can get in the restaurant, no one can write a check, business is closed, I don't know if people are going to be winning a lot of fines for late paychecks. I've had a couple calls where they seem more interested in getting the fine for the late paycheck than kind of like, where's the money and am I going to have a job when I come back? And it's a day's pay, up to 30 days for these late checks, but I would be more concerned about if you're going to actually get the money than the fine, because there's so much discretion. There's also discretion with PAGA where the judge can give you less than the total amount of the PAGA penalties. Okay, so next week is my last week on KABC. It's very sad. I'm going to see if I can get some of their characters to call in, but given the situation right now, we can't really be doing shows with a bunch of voice actors all together at the same time. The Zoom quality just wasn't that good. You need to subscribe on the Karl Gerber with the K channel to figure out where the show is going, because it's going to another radio station, but it's going to be just on YouTube a little bit. And I want to make sure you have my phone number. It's 877-525-0700. As you can see tonight, I'm knowledgeable. I'm serious too. I think that the comedy thing was a way to educate people on employment law. And I had a lot of airtime to fill. And I think if I talked like this every time with just me, it's boring. I didn't want to give you that kind of a program. I wanted to give you something really special. And that's what I did. Who else was able to write scripts like that every single week? Nobody does it. Just just one person. 877-525-0700 if you want a lawyer that can write the way I do. I can write. 877-525-0700. This is the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC, and we will be back next week. Hey, that's not the I Love LA you know, is it?
This show is pre-recorded and furnished by Karl Gerber and Employment Lawyers Group.